request on what kind of information you'd like to hear from us as a group. Today we have Jeremy Schneider back from Jackson Lewis. We're happy to have him presenting again on some legal updates and get really a sense of what's happening in this kind of ever-changing landscape of this vaccine and COVID environment. Going through some of these slides, I wanted just to open up with a couple comments. One, first, please do mute your line as you're joining the call. We will have plenty of Q&A time, I'm sure. Feel free to use the chat section. In addition, we will be recording today's call. We'll be distributing the material afterwards. Again, I'm Dario Camplatero, Managing Director for Hill Group Mid-Atlantic, and we've got Molly Jackson, Benefit Specialist for Hill Group Mid-Atlantic. Molly is instrumental in coordinating, facilitating, managing these webinars, so I appreciate all her efforts and hard work in doing these webinars, and she will continue to play an important part going forward, and maybe even a bigger part going forward. So I want to thank Molly for her contributions. If we go to the next slide, this is a brief description of Hill Group Mid-Atlantic. Really, what I would tell people for clients of ours who are participating today, and or if you're not a client of ours, is we really try to focus our services to our clients on delivering a very personal, very regional, high-touch strategic relationship. However, we have very deep resources as Hill Group Mid-Atlantic. We're a top 20 insurance brokerage in the country, that we can provide a lot of resources to the table. And one of them, quite frankly, is having access to somebody like Jeremy Schneider. I'll take one of his lines from him that, how often do you get an attorney that you can ask questions to for free? This is one of those great opportunities that as a Hill Group client or a friend of the Hill Group, let's call it, in the Mid-Atlantic region, that you have that kind of access. So what I always tell our clients is, if there's something you need, something you're not sure of, a resource, a tool, a challenge, an obstacle, please come to us. Chances are we probably have a resource available to help you overcome that. And if not, we'll figure something out for you. So again, we're happy to work with the clients in the DC metro market, as well as throughout the Mid-Atlantic region, and more importantly, across the country. So thank you very much. The next slide is touching on, I think, our upcoming, okay, yeah, just compliance.
I'll stick it here.
Just the next couple slides. It's really about resources and tools that we provide. Compliance is always a standout right now. Communication is another big area. I was on a call with one of our leaders in the Mid-Atlantic region, or on national level, and he really talked about, the value proposition for Hill Group is the 3 C's: cost, communication, and compliance. And those are really 3 pillars that our clients look to us for, and we really try to educate and support our clients. The communication one's an interesting one over the past year. For example, these webinars is one model of how we provide service to our clients through communication. But I think the biggest challenge and a big opportunity that's happened over the past year is employee engagement, where we've been talking about employee engagement and wellness and awareness for many years, but unfortunately the pandemic really pushed that to the forefront. Things like telemedicine, taking advantage of EAP programs, and resources like that, overall employee well-being. That's an area we've spent a lot of time in advising and supporting our clients over the past year, which I believe will be a nice, durable feature and capability that we will continue to push forward with our clients going forward as we pull out of this pandemic. So again, we're happy that we're able to do these types of things for our clients. Look to us where we can try to help and plug into your organization. And I think one of those will be in the next slide, is our presentations that we've got coming up. Obviously we have Jeremy today, but the April 30th is a great example of this. We did one of these last year, which really the objective here is, this is not necessarily only for employer facing content, our Spring into Wellness webinar. It's really an opportunity for you as our clients and employers in the area to push this out to your employees. The purpose of this is having somebody from Inova as a coach, as a health coach, really being able to present content that this goes down to the individual employee, dependent, spouses, and really the population at large. So we encourage you, as this information comes out on this webinar for April 30th, to really distribute it to your employee population. Again, anybody and everybody is welcome to attend this. This is not just for employers. It's not for HR professionals or just executives. It's for anybody within an organization, really anybody and anybody can attend this and get something out of it. So we're excited about that, being able to do those types of events. And then on May 7th, we've got HR Knowledge, Melissa Gillespie. HR Knowledge, again, is one of our sister organizations within the Hill Group. Again, talking about things surrounding COVID, from surviving to thriving. We're almost there. So hopefully that, we'll have continued good news as the vaccine rollout continues to accelerate. And then on May 14th, our very own subject matter expert, Margie Grubik. Many of you maybe have heard Margie Grubik speak at our events in the past when we used to do them at Tuskegee and Leesburg, or Ruth Chris and Tyson's Corner. She'll be talking about the COVID relief bill. So we're excited about that. And who knows, fingers crossed, maybe by the end of the summer, early fall, maybe we're going to be back in a restaurant setting, having interpersonal relationships and being able to do these events in person. But we'll see. Stay tuned for that. So thank you very much for that. And also, these recordings are all presented on our YouTube channel. And so you can find a library of today's presentation as well as past presentations at that YouTube channel. And as a reminder, you'll get a copy of today's presentation along with the recording or a link to our YouTube channel by the end of the day today. So I think that puts us into our presenter today, and Jeremy Schneider, which, again, I can't thank Jeremy enough to be a presenter. This is the third time he's speaking to us and our group. We always have great response when we're presenting Jeremy as a speaker. And Jeremy and I are friends. We both sit on the board for Louden Sherm here in Leesburg, Virginia. So, he is totally plugged in, obviously from a professional level, even a personal level with human resources and all things surrounding the subject when it comes to employment law. And Jeremy, I'm going to turn it over to you to take us through today's presentation.
Okay, great. Thanks, Dario. Appreciate it. It's good to see some of you again and good to meet some of the new folks. I'm going to jump right in. We have a lot of content because it continues to be a pretty crazy environment we're living in. And, I'm going to just real quickly, this is my bio. I'm not going to bore you to death with my bio, but I'm a employment lawyer with Jackson Lewis. Our office is here in Reston. We are a national labor and employment firm. We essentially do anything having to do with the workplace. For my part, what I spend most of my day doing is helping clients manage the risk that's associated with their employees, and help them manage legal costs that could be associated with that, and reduce the legal costs by hopefully preventing disputes before they turn into something more formal. And then, of course, if unfortunately that plays out, we defend clients in state and federal court, and in arbitrations and before administrative agencies. A little bit about the firm. We represent management exclusively, so we don't represent employees at all. We really try hard to learn about our clients' business to make sure that the advice and the counsel that we're giving them jives with their organization goals, with their business goals, and that we, instead of being, the kind of classic lawyer who tells you what you can't do, we try to work with you to come up with creative solutions that line up with your business goals, and so and manage the risk associated with any of those decisions. We've got a long-standing kind of 5 pillars of client service. I'm not going to go through each of them, but we really do try to provide the best level of customer service to our clients whatsoever. We've got 61 offices all over the country, 950 plus lawyers. Our office, I like to think of our office here in the DC metro area as sort of a microcosm of the entire firm. We're about 28 or 29 lawyers in our office now, and we've got a good representation of all the different practice areas of the firm. So if you were to call me, I usually, in a pre-COVID era, would just walk down the hallway and talk with a subject matter expert if it was something that I didn't know about, or I would help you myself. These are our different practice areas. Like I said, it's really anything having to do with the workplace: wage and hour, white collar, criminal investigations, corporate diversity, which is a huge topic right now, corporate governance, disability leave, and health management, which is a huge topic right now. We're going to get into some of that when we're talking about vaccines and return to work. Workplace safety is another issue that's obviously on the forefront of most employers' minds. We're going to talk a little bit about that. We also are tapped into a number of industries, government contractors in particular in our office, retail, healthcare. A lot of our clients come from those industries, and so we're very in tune with the needs of each of these industries. Okay, what are we going to talk about today? So in our last two sessions, we talked a lot about ongoing COVID-19 issues. We're going to talk about them again today. We talked about some federal legislation, mostly in the form of the relief packages and the spending bills. There's a couple new things under federal legislation that we're going to talk about that just came out of the American Rescue Plan. And we're going to talk about some new state and local legislation. You know, Virginia just keeps continuing to confound expectations. Virginia, traditionally, as a southern state, has been very conservative, not particularly employee friendly, and not passing a whole lot of laws. But Virginia just keeps passing laws that impact employers. It seems to be happening every month. There's a couple new ones that you all are going to want to keep your eye on as we get close to July, which is when most of these laws go into effect. We're going to talk about some other issues like the sort of what we are viewing as a forthcoming wave of COVID-related litigation. We're also going to talk about a handful of other issues that are really top of mind for employers right now. And then, like Dario said, we're going to do like a Ask Me Anything session. So I hope to have at least 15 minutes at the end where we can chat about whatever it is that you all want to talk about. Also, feel free to use the chat function. I'm not sure if I can see the chat function on my screen, but if maybe Dario or Molly are willing to let me know if questions come in, we'll take them as they come. Okay, so COVID is still going on. We are looking like things are picking up a little bit, getting more back to normal as vaccinations continue to roll out. So a lot of employers right now, spent probably 10 to 20 hours this week talking to clients about return to work plans. So this is the hot topic right now. So what are other businesses doing? You're probably asking yourself, okay, what are other businesses like mine doing? Most of our clients are gearing up for a mid to late summer or early return to the office. And that's, of course, assuming that infection rates continue to decline and the vaccinations don't slow. The rate of people getting vaccinated do not slow. A lot of our clients are asking us, how is it that we structure a return to work? I will also tell you, and I haven't put this out there, the firm hasn't put this out there, but Jackson Lewis is planning on returning our folks to work sometime in the next couple months, not full time. We're going to do a staggered approach, but the goal is by September, most of our staff is back in the office. So what are the things that you should be thinking about? If you're thinking about return to work or you're considering those questions, you're going to want to develop a return to work plan, and you're going to want to consult with HR, your leadership, and counsel. You're going to want to communicate openly and regularly with your employees about the return to work. You're going to want to seek their feedback. And that, for some of my clients, has been particularly helpful. You're going to want to think about tailoring your plan to your work environment. So in some of these prior discussions that we've had, we've talked about, what are the different workplace safety expectations depending on your work environment, your physical work environment. So if you're working in a factory where everybody is sort of already on top of each other to begin with, and there's no way to mitigate that, you might have a separate set of concerns than you would if you were in a normal office environment, right? But even in a normal office environment, you're talking about offices, cubes, and a lot of cubes are not set up to keep people 6 feet apart. The partitions may not be high. There's a lot of those different factors that you're going to want to think about when you come back to work, because it looks like most of, and this is what we got sidetracked talking about before the presentation started, most of the social distancing, mask wearing, and other safety measures look like they're going to remain in place for the foreseeable future, even if you decide to bring folks back to the office sometime in the next handful of months. And we'll talk a little bit about more what the requirements of that might look like when we get to another section of the presentation. You're going to want to think about, what are your workplace safety priorities? What are the things that you are doing right now when maybe only a handful of people are regularly in the office? And then what might you do when everybody is back in the office? And then you're going to want to think about, where do vaccinations fit in to this plan? And that's sort of how I've been helping our clients talk about the issue of vaccination. We start with, okay, when do you want to return to work? And then we work backwards from there, folding in vaccinations where it's appropriate. The idea of thinking of vaccinations as the first and primary thing for, what you're doing right now, because it is obviously a very pertinent topic, isn't necessarily the right way of thinking about it. If you don't have a plan to return to work and you feel like your folks can continue to work remotely, the idea of vaccinations may not be all that important if you have a continuing remote workforce. So we'll talk a little bit about vaccinations. That's our next topic. So the big question is, do you mandate or do you not mandate? We talked about this last time. And the EOC's vaccine guidance does permit employers to require their employees to be vaccinated, but those requirements are subject to a sort of a complicated framework of exceptions. The EOC has carved out exceptions for example, employees with disabilities or employees with sincerely held religious beliefs that preclude them from getting vaccinated. And so when you do mandate the vaccines, the EOC's guidance is fairly comprehensive. It lays out a number of requirements and things that you have to do if you decide to mandate. I will tell you, most of our clients are not requiring vaccinations. So instead, what they're doing is they're encouraging their employees to get vaccinated as part of a workplace safety or return to work plan. Again, Jackson Lewis, if you want to use us as an example, the head of our firm sent everyone in the firm an email about a month ago saying that the firm strongly encourages everybody to get vaccinated, and letting folks know that the firm has a plan in place to return to the office in some form or another in the coming months. And there have been subsequent communications in that regard. We talked about that earlier when we were discussing return to work plans. And then, of course, this is an individualized decision. What you're going to do, mandating or not mandating, is an individualized employer-specific consideration. For example, government contractors, a question that comes up all the time is, what are we going to do if the government customer, where our employees work physically, requires people to get vaccinated? And there's a whole host of considerations that go into that dynamic. And so you need to be prepared to be nimble, to make individualized assessments about certain subsets of your employment force, your workforce, who may work in a government building or not. The government hasn't made that decision yet, but I can imagine that individual agencies are going to say, in order to be on site, you need to be vaccinated, and they certainly would have that authority. And so what are you going to do about that? And how do you navigate? Then you've got sort of a subset of your employees that are going to be required to be vaccinated, and you got to deal with all these other issues as if you made that decision yourself. And so, it's not easy. It's going to be something that employers are going to struggle with over the course of the next couple months.
Hey, Jeremy, if I can ask a quick question.
Sure.
Is in the healthcare space, HIPAA, right?
Mm-hmm.
So now we're asking employers, or some employers may be asking or getting confirmation regarding what I would say is personally identifiable health insurance information. Has that come up as a issue?
So you're getting right ahead of me, right?
Oh,
So
okay.
tracking, you're like, we're right here. We're mind melding one another. So tracking employee vaccinations is a question that I'm working with clients on right now quite a bit. So, and this is how it comes up. They're thinking about returning to work. They're thinking about the safety of all the people who are at work, and they want to know whether or not their employees have been vaccinated. So what does the EOC say about this? The EOC essentially says that you can track. It's not explicit, but the EOC does kind of tacitly authorize employers to track whether or not an employee has been vaccinated. The EOC has also said that receiving the vaccine, actually getting the shot, and asking about vaccination status is not a medical exam or a disability-related inquiry. And when you ask an employee for medical information or disability-related information, there's a whole host of other issues that come up. How do you safeguard that information? What are the questions that you can ask? Is it related to their duties and responsibilities, right? There's a whole level of analysis there. But the EOC has essentially said that tracking simple yes or no and other non-medical information related to the vaccine is okay. And there are some issues where you need to be careful, of course. On HIPAA, the issue here is the EOC is saying it's not medical information, a simple yes or no confirmation of receiving the vaccine. But we'll get into it. But what we're telling our clients is if you're going to track, you might want to take some additional steps to safeguard that information and sort of assume that it is medical information, even if it isn't. So you're going to want to be careful if you start tracking vaccination status. Certain questions can elicit a response that's going to give you medical information. So think about this. If you ask an employee an open-ended question, have you received the vaccine? If the answer to that question is no from your employee, it's very reasonable to expect an employee to say no, and I'm not going to receive it because of X, Y, and Z issue, right? And that issue, if it's disability related or it's medical related, now you're an employer with medical information that you didn't even necessarily ask for, right? And now you've got safeguarding requirements, and you've got other burdens on you now because the employee has given you this information, right? So that's an issue that you really need to be careful about. So how do you manage that? You're going to want to use some best practices. You're going to want to limit the information an employee can provide. So I've helped a number of clients come up with a fillable form for tracking vaccination status. Basically a checkbox yes or no. Have you received the vaccine? Check yes or no. And that's it. They can't provide any other information. If you have received the vaccine, which dates have you received your first and second shot? And those boxes for first and second shot only allow you to fill in the date that it's in that format that no one can write a narrative response. And then a question like, do you plan to receive the vaccine or do you plan to be vaccinated? Checkbox, yes or no. And on top of that form, would typically say something like, Acme Corp is asking for this information to develop a return to work plan and monitor and actively manage the safety of the workplace going forward. Please do not provide any additional information other than what is specifically asked in this form. So you're warning your employees, do not give us any more than what we're asking for, and you're giving them a form that doesn't even allow them to do that. And that's what you're going to want to do. Then once you have that information, now you've got a spreadsheet that's tracking vaccination status for your workforce. You're going to want to treat that information as if it were medical information. And even though it isn't, we are advising our clients to do that because in certain states, there are some additional requirements and some additional sort of areas of the law that you can run afoul of. So for example, California has a comprehensive privacy law, a comprehensive confidential information law, and California hasn't issued guidance about whether or not vaccine status triggers those requirements, but we're telling our clients, look, California is crazy. They will do anything to make it more difficult for employers, and so just safeguard that information like you would any other medical information. So what you do in that case is you get the information, you store it in a separate file outside of a personnel file. You limit the access of the people who can get that information. So typically it'd be HR only or HR and senior leadership only, right? People would need to know. I've gone through third and fourth. So fifth, you're going to want to be transparent. You're really going to want to develop a communication plan for how you're going to roll out not only return to work, but what you're going to do to manage if you decide to track vaccination status. And you want to make sure that you tell your employees, we're not going to use this for any other purpose other than maintaining a healthy and safe working environment for all the employees as they return to work. before we get into workplace safety, I'll just mention for those who weren't on the previous webinar and those who maybe didn't have a chance to reach out to me last time, I've got some materials and FAQs on vaccinations that I can give out. I'm happy to give out to anyone who reaches out to me. Either just send me an email or connect with me and send me a message on LinkedIn, and I'll send you those materials. They're a nice, helpful, very user-friendly guide with a lot of questions and answers in it from our folks. We're giving those to clients. I'm happy to give them to you all. So on workplace safety, last time we spoke, we talked about OSHA and President Biden's executive order that required OSHA to issue a comprehensive workplace safety standard on COVID-19. And the deadline for that was March 15th. That deadline has come and gone. We're now 30 days past that deadline, and OSHA hasn't issued its standard yet. When we were in the lead up to March 15th, the interim OSHA director asked President Biden for additional time. And the reason being, they wanted to study the data in the different states as the vaccines continued to roll out and sort of modify and massage their standard based on that information. We expect that standard will be issued in the next 30 days. What is the standard going to look like? So the rumor is that it's Virginia standard is acting as the model. And we talked about Virginia's standard in the last two sessions, but Virginia's standard was the first comprehensive and required workplace safety standard in the country. It came about early last year or late last year. And it requires basically an assessment of the workplace from a safety perspective in multiple tiers. So sort of low risk environments, like a normal office environment, had a certain number of standards under it that they had to adhere to. A medium risk, which is an environment where the public can enter and exit, like a retail establishment that has separate list of standards, and then sort of high risk workplaces, which are sort of inherently dangerous to begin with outside of a pandemic situation. So poultry packing plant, a mine, a factory, places where there's already a significant amount of risk. What do they have to do? Or places where you can't socially distance sort of comfortably. And the requirements go sort of from sort of moderate to light all the way up to fairly severe. There's also reporting requirements and things like that built in. So with it in mind that Virginia's standard is going to be the model, what are some of the things that you can expect? So you can expect a requirement that employers provide telework and staggered shifts when it's feasible, providing hand washing stations and hand sanitizer, which most employers have done already, and it wouldn't be a significant burden. Assessing risk level of employers and suppliers before entry, notifying OSHA of positive tests, and that would depend on the number of positive tests in whatever time period. So in Virginia, for example, the original standard said 3 positive tests within a 7-day period required. Notification of Virginia OSHA. They loosened that to 3 within a 2-week period, and then they loosened it further to 3 people who are physically close to one another in a certain time period. So not sure exactly where OSHA is going to stand, but there likely will be this piece of it. Assessing hazard levels of all job tasks, providing COVID-19 training, safety training, preparing infectious disease preparedness plans, and post or presenting materials. So like your minimum wage poster, there would be an OSHA safety poster for COVID. So here are some things that you can do to get ready, because coming in 30 days, this stuff is going to be mandatory. You're going to want to look at your COVID prevention program. If you have one, consider adopting additional elements to align with OSHA's recommendations. OSHA has issued some guidance in the last couple months before issuing the standard. You may want to look at that guidance, and that might give you a preview of the type of stuff that they're looking for in the standard. I will tell you that in our Richmond office, a partner of mine named Courtney Malvo used to be the head of Virginia OSHA. And when Virginia set up its standard, they called him in to help write the standard. And Courtney is fantastic at making this stuff pretty easy to understand and comply with. It's usually a 30-minute phone call, and he boils it down to the most simple way that you can comply. He'll be ready to do that when the federal OSHA standard comes out. If you feel like you're swimming in regulations, he wrote the model. So he'd be a great resource for any of you. You're going to want to evaluate the availability of vaccines in your state and locality. So here in Virginia, fairly easy at this point. Virginia is doing a very good job of vaccinating its residents, as opposed to a handful of other states, which really aren't doing that well. And there are some that are doing better than Virginia, but we're in a good spot. So you want to think about how do vaccines play into our safety plans. You're going to want to keep monitoring the new guidance as it comes out. And then, of course, you're going to watch out for that standard in the next 30 days. It's going to be mandatory.
Hey, Jeremy, if I can ask another question.
Sure.
At the OSHA standards, especially the slide that you had prior to that with that list of items, it seems like as vaccine rolls out, more people are vaccinated, that could these standards change quickly again, where some of these requirements become less important? Some of them are good, durable, lasting components of this, but do you think they could change, and how quickly could they change as we see the vaccine?
They could change quickly. What they could also be based on is the level of community spread at any given time. They might say, if you are operating in a state with a certain threshold of cases per 100,000 tests, they may stagger it that way. Virginia's standard didn't stagger it that way. Virginia's standard essentially said these standards apply until the governor lifts the state of emergency. So if the governor were to lift the state of emergency, those standards would go away until it was enacted again. I don't know what the federal equivalent of that would be, or if there would be one, or if they plan to put something like that in there. But yeah, there's a chance that it could change based on the level of spread, the level of infection, et cetera.
So for clarity, just so I understood, the state of emergency, if that state of emergency was ended by the governor, then these OSHA standards and requirements would no longer be required.
It would no longer be required, but there is a provision in the law authorizing Virginia OSHA to promulgate additional or subsequent standards based on whatever it is that the governor decides, right? So the governor may lift the state of emergency for certain counties, or it may lift the state of emergency for, they really are going to be, and have been for a lot of these things, flexible and targeted, right? You remember back in the summer where Loudoun County was one of the last counties in Virginia to ease some of the restrictions when it was like Norfolk and Loudoun and Fairfax, where there was kind of hit pretty hard. They were keeping the standards higher than what the governor was saying. They may do the same thing again, and OSHA may react in that way.
Okay, thank you.
All right. So federal legislation, the American Rescue Plan, that was really the big thing that has happened in the last couple months. So it's the most recent stimulus bill. It's targeted to, address the pandemic issues. It was passed basically a year after the first relief bill with the Family First Coronavirus Response Act, the FFCRA. The employer leave obligations in the FFCRA, they ended on December 31st. So employers are no longer required to provide emergency family medical leave or extended family medical leave or emergency paid sick leave, which were the requirements under that law. When the budget passed, the Appropriations Act passed in December, it didn't extend those obligations. But instead of extending them, what it did was, it gave employers the option to voluntarily decide to give those that type of leave in exchange for a tax credit to be claimed later, but it is still entirely voluntary. So it doesn't mean, and then the American Rescue Plan passed about a month ago now. and it didn't, it extended the length of time in which an employer could offer the leave and get this tax credit, but it didn't require that employers extend the leave to their employees. For those employers that choose to voluntarily provide the leave, you can do that until September, the end of September. That's the deadline for offering that leave and claiming the credit. And then it also expands the reasons why an employee could get the leave if an employer decided to offer it. So for example, you'll recall in the first set, it was you could get emergency, family, and medical leave if your children's school was closed. That was the only way you could get that piece of it. Now it's basically anyone trying to get a diagnosis for COVID and any of the other reasons for emergency paid sick leave, like getting a diagnosis, getting tested, presumptive positive, et cetera, or under a quarantine order. There's just basically all of the reasons where you could have gotten either extended FMLA leave or emergency paid sick leave are now all subsumed under emergency paid sick. And I mean, you can get any of them for any reason. So it's up to this 2 weeks and there's a certain threshold. And then the extended FMLA is an additional 12 weeks of unpaid leave, paid at a certain threshold for a certain period of time. And that's the qualifying credit that you can take at the end of the year. I'll just tell you that 90% of my clients are not offering that leave to their employees, that the sort of administrative headaches associated with granting those types of leave requests are onerous and not worth the tax credit. But you can, I have one client that is offering it. They're operating facilities where people are testing other people for COVID and are running vaccines. And so they feel like those folks should get it because there's a likelihood that they will at some point have to quarantine or they may get sick. Another big thing that came out of the plan was this COBRA continuation coverage election issue. So the plan creates a 6-month subsidy period from April 1st to September 30th. And during that period, certain assistance eligible individuals can qualify for 100% subsidy of the COBRA coverage. And what that means is that the employee would pay no cost for monthly COBRA premiums for medical, dental, or vision coverage if they're eligible for COBRA coverage during the subsidy period. So if you terminate somebody right now and they enroll in COBRA, they are eligible for free COBRA until September 30th of this year. It doesn't extend the maximum COBRA coverage period. It essentially suspends the obligation on the employee's part to make COBRA premium coverage payments for up to 6 months. And they're not optional for employer-sponsored group health plans. So all group health plans subject to COBRA have to provide this subsidized coverage. So the employer has the obligation to provide the coverage. The employer has to advance the premium costs. And then later, the employer can recover the cost of that coverage from the federal government by claiming a credit against its quarterly Medicare payroll tax liability. And then there's new notice requirements for group healthcare plans. You have to basically tell these folks that they have this, they are eligible for this coverage, and that they need to enroll in it. And there's a required notice of the availability and the notice of the extended election period for COBRA coverage and a notice of the expiration date. So you have to give all that additional information. But a lot of our clients are having an issue with that now because they're going to have to front that cost for a certain period of time until they're able to claim the credit. I don't claim to be a tax lawyer. In fact, I very explicitly disclaim that I'm not a tax lawyer. We have tax folks that really understand this and have dove into this issue really hard. If you have a question about it, I'm happy to hook you up with somebody who's much smarter than me and really understands this stuff.
And Jeremy, on this particular point, is anybody on COBRA eligible to qualify for the subsidy? There's no other criteria other than just being on COBRA?
So it's you have to be otherwise qualified for COBRA. So whatever the normal qualifications are to get COBRA, you have to be otherwise qualified. They also have to enroll. So if somebody just lets the die on the vine, they don't get it. but they get the notice and they let it die on the vine. They don't respond. They don't enroll. They don't get it. But then once somebody is enrolled, everyone who is enrolled and COBRA eligible gets this benefit, 6 months of COBRA subsidies.
So basically,
Up to.
somebody who's enrolled in COBRA goes out on COBRA. Excuse me, the first 6 months basically are subsidized through this tax benefit of the federal government that the employer's fronting up front.
Right.
Is that the way I understand it?
That's right. And then the employer can claim the credit against its Medicare payment,
Right.
the quarterly Medicare payment. And then after the 6 months, it reverts back to normal. It doesn't extend the length of time that somebody can be on COBRA. That stays static. But after the 6 months is over, then it's normal, like it otherwise would be.
Okay.
Jeremy, I believe, this is Petya, I believe if somebody resigns, they're not eligible for this subsidy.
So people who resign are eligible for COBRA.
Yeah, they're eligible for COBRA, but not for the subsidies.
I believe that is true. Although again, this is not my area, but I believe that is true. I've read a couple little blurbs that our firm has put out on this topic, and I recall reading that.
Oh, okay, thank you.
And Jeremy, we do have another question. Maybe it goes back a
Sure.
step, though. If I ask it,
Heard it.
it's regarding the voluntary FFCRA. Is it an all or nothing decision, or can an employer decide how much FFCRA leave they can provide?
If you offer it to someone, they are eligible for up to the total amount. So you can't say to them, we're only gonna give you,
2 hours to get a vaccination, for example.
well, if that's what they need, then you can give them that, right?
Right.
But you can't just say to them, okay, you want emergency paid sick leave. The most you can get is 1 week when you're required to give 2 weeks. And the same with FMLA, the extended FMLA. You can't. That situation is just like when somebody goes on FMLA, normal FMLA. It's just extended and it's partially paid. And so you have to go through that process, whatever the doctor says that they need, or if it's intermittent or not. I mean, there's a lot of different wrinkles here, but you treat it like somebody is going on FMLA and they're eligible for up to the maximum amount.
Okay, so that they basically can have the maximum amount. The employer can't limit it, but the employee can use it as they need it. Not
No.
Right. Okay.
What some of my clients are doing, if they don't want to offer it, really it's all about the tax credit. If you don't take the tax credit, you do not have to offer it to your employees. So I have one client who is giving their employees 2 weeks of extended, they're giving it 2 weeks of, everyone in their company is eligible for 2 weeks of paid sick leave if they test positive for COVID. But they're not going to claim the tax credit. This is a purely gratuitous benefit. And so you're only subject to the requirements of the FFCRA and the emergency FMLA if you take the credit. So you can offer something, but you just can't take the credit. But I would, very clearly communicate to the employees that this is gratuitous. It's wholly separate from the FFCRA. It's not related in any way. We're paying for it out of our pocket. We're not taking the tax deduction. We're not otherwise required to give you this leave. That would be the type of stuff you'd want to communicate to your employees so they don't think that they're getting this leave and there's all these other requirements that you have to meet.
Understood. Thank you.
Okay. So state and local. Virginia is just rolling along. So Virginia amended its Human Rights Act to expand the scope of it to prohibit discrimination on the basis of disability. Prior, they were just sort of relying on the federal, on Title VII or on the ADA for disability discrimination protection, but now they just rolled it into the Virginia Human Rights Act, which a lot of you will recall that last July, the Virginia Human Rights Act expanded greatly. It has a ton of new remedies, a ton of new potential claims. It allows employees to file a claim with a Virginia state agency like the EEOC that will investigate their claims. And so this is just another expansion of that. It also requires that employers provide accommodations for disabled employees, much like the ADA. Virginia also passed paid sick for home health workers. So this is very specific. It's not for every employer, but it's for home health workers. And it joins the District of Columbia and a bunch of other states which have paid leave for designated workers. It's compensated at the same hourly rate, the same benefits. The law provides home health workers averaging at least 20 hours per week or 90 hours per month with paid sick leave. Excuse me. And home health workers are individuals who provide personal care, respite, or companion services to an individual who receives consumer-directed services under the state plan for medical assistance, so Medicaid. Virginia also amped up its overtime law. It had an unpaid wage law, sort of toothless. Last year, they revised that law to make it to expand its remedies. So beginning on July 1st of this year, employers are subject to new state overtime pay requirements. Previously, like the Virginia Human Rights Act, Virginia sort of relied on the FLSA for its wage issues. But here, the Overtime Act obligates employers to pay 1.5 times an employee's regular rate of pay for every hour worked under 40 or over 40 in a week, which is the same as the FLSA, but the departures are how the regular rate is calculated, has a longer statute of limitations. It also has expanded damages. So the FLSA is 2 times damages. You get your wages that are owed plus an equal amount of liquidated damages. And under the Virginia state law, it's the amount that you're owed and double liquidated damages, and then treble liquidated damages if it's a knowing violation. So greatly expanded remedies. Virginia also, in another shocking twist, if anyone's lived in Virginia for more than 5 years, we have legal marijuana in Virginia now, where we're going to in July. So anyone over the age of 21 will be able to lawfully possess up to an ounce of marijuana in Virginia. It creates a cannabis control authority, which essentially will regulate the legal sale of marijuana within the state. So think Colorado and Washington and Oregon and these other states that have California, which have legal marijuana. That's what we're heading toward. In March, they amended the state medical cannabis law to prohibit discrimination against lawful users. So you can't fire somebody for having a medical marijuana card. The law, which becomes effective in July, doesn't restrict employers from taking action based on workplace impairment due to cannabis oil. So if somebody is high on cannabis oil, or even if they have a medical marijuana card, but they're impaired at work, there isn't a remedy for someone who gets fired for that. It's a legitimate termination. It also has limitations really for government contractors. So you have contracts with the government that require compliance with the law, result of a federal contract, or result of a loss of a federal contract or federal funding, and for defense industrial-based sector employees. Here are some other issues, and I'm going to go quickly through these because I promised 15 minutes, but I realize I'm over by 5. So EEO1 reporting is back. They suspend the EEOC, suspending it during the pandemic. There are new deadlines, and you're going to want to watch out for those. This lays it out. Dario and Molly will send you all the slides afterwards, so you'll have that. PPP enforcement is sort of picking up steam. You'll read on the news about PPP fraud, people buying Ferraris and giant houses with their PPP money. I assume nobody on this call did that, but what you need to think about is technical compliance with the requirements of the PPP loan. Make sure that you're on top of what it is that you have to do to get forgiveness, et cetera, because the Department of Justice is coming after people. And here's some stats on COVID litigation. So really in the latter half of last year and into this year, the number of cases filed against employers for COVID-related reasons has really ballooned. And now that things are opening up and people are moving more freely, we expect that trend will continue. And so you just want to keep your eyes out on a lot of these things, especially when you start returning to work. and people start telling you they're uncomfortable being in the office with other people, you could be running into some kind of COVID-related compliance issues. And here's the Ask Me Anything. So 10 minutes, and I'm happy to go over if anybody wants to stick around, but I will answer anything. I mean, absent personally embarrassing things about myself or something like that.
Well, we appreciate it, Jeremy. Certainly open it up to anybody who'd like to unmute and ask a question. Jeremy, any legal topics I think are on the table?
Hi, Jeremy. This is Therese Winnigan
Hi.
from the U.S. Navy Memorial.
Hi, Therese. How are you?
Hi.
Good to see you. Now I see you there. Okay.
I have questions because I'm in Washington, D.C.
Okay.
So I just wanted to just kind of know the regulations for D.C. because you said Virginia, but I think, did I miss D.C.?
For what topic? Regulations for what topic?
I guess the would I still be able to do the letter of encouragement and then the return to work plan and and also being able to ask the open-ended question to the employee if they've been vaccinated? And
Sure.
the form and everything, is that okay with, I guess?
Yep. It would be. It would be. So the DC government hasn't issued any kind of regulations or guidance on tracking vaccine status. Neither has Virginia, quite frankly.
Okay.
The federal law is really what we're sort of working off of. The EEOC has made some statements, answered some FAQs that sort of tacitly authorize employers to track the information we talked about.
Okay.
You know, in DC, there's right now, there's more unique issues with return to work issues in DC. Like DC is still relatively conservative in terms of what they're willing to let people open up and do whatever, right? So if you're thinking about return to work and vaccines as part of that, I would caution you or recommend that you sort of really understand what the DC requirements are for people coming back to work and whether or not a certain number of people can congregate. It is different from Virginia to DC and Maryland too. It's sort of a patchwork for each.
Okay. Thank you.
Sure.
And so this whole slide deck I can get, how can I get that slide deck again?
Dario will send it around to everybody when we're done.
Oh, great. Thanks.
Yep.
Yeah, we'll distribute the slide deck and a recording of today's webinar as well.
Awesome. Thank you very much.
Thank you. Thank you for the question.
Yeah,
Any
good
other
question.
questions? Well, as we're wrapping up, certainly feel free if there's a question. I wanted to thank Jeremy Schneider for presenting again today. Really what is an evolving landscape of legal, maybe minefields is not the right word, but certainly requirements and legislation that we need to be very aware of. And I would imagine it's going to continue to evolve here over the next few weeks and months, and some will remain durable probably, and some will maybe go away, hopefully, as things start to normalize again. So thank you so much, Jeremy. And I encourage anybody on the call, feel free to reach out to Jeremy. He's been a strategic partner to the Hill Group in the Mid-Atlantic region, certainly on topics like today or other topics. I'm very capable and competent attorney as well as organization that can help you navigate some of the issues that we all deal with in our workplace. So thank you, Jeremy.
I appreciate that. And if anyone just connects with me on LinkedIn, you don't even have to talk to me, or you can ignore me after that. But the firm, I'm very active on LinkedIn. I share a lot of the firm's resources on LinkedIn. A lot of people get a lot of value out of that, and you'll never hear from me. Just feel free to reach out.
Thank you, Jeremy. And again, today we'll get Molly will send out the presentation along with the recording by close of business. Is that right, Molly? That's usually your time frame.
Yeah, by the end of today, they should get it.
Okay, great. And stay tuned for our upcoming webinars. I shared a little bit about those coming up. We also have an exciting one that will probably be in late May, maybe early June, regarding an employee benefits captive an innovative way to structure your benefit package for larger employers. So stay tuned for that. And I'll just end with this. Thank you so much for attending. If you're a client, thank you so much. If you're a guest, we appreciate taking some time to spend with us. Please consider us as you're evaluating your employee benefits, your business insurance and or 401k. If anything, we can be a due diligence and a second opinion for you. It does no harm to kind of get a second opinion. So we're here for you. You can see our contact information here, and then please check out our YouTube channel where we have a library of all these presentations. And we look forward to seeing you again here in a couple of weeks. So thank you, everybody, and have a wonderful weekend. That concludes today's webinar.
Thanks, everyone.
Thank you. Thank you, Jeremy.
Thank you.